When a police officer signals you to pull over, the very first and most important step under US law is to remain calm, act safely, and demonstrate that you understand the seriousness of the situation. Legally, the officer must have a valid reason for the stop. This is known as reasonable suspicion, a standard established in Terry v. Ohio, 1968, TWEES, which allows an officer to briefly detain you if they reasonably suspect a law violation. Reasonable suspicion is not the same as proof, but it cannot be based on a mere hunch. Must be tied to specific articulable facts, such as speeding, reckless driving, a broken taillight, expired tags, or a violation the officer believes you may have committed. Once you see flashing lights, US law expects you to pull over promptly but safely, meaning you should signal immediately, reduce your speed, and move to the closest safe location, preferably the right-hand shoulder or a well-lit public area, if safety is a concern. This demonstrates compliance and prevents an officer from interpreting hesitation as potential evasion. Turn off your engine, roll down your window, and place your hands clearly on the steering wheel in plain sight. Legally, officers are trained under the principle of officer safety doctrine, which means they can take reasonable steps to protect themselves during the stop. Visible hands instantly reduce tension. 2. Not start searching your car, opening compartments, or reaching for documents until the officer requests them. Early movement is the #1 cause of escalation because officers cannot determine whether you are reaching for a weapon or simply your wallet. U.S. courts consistently support the officer's right to approach cautiously under Pennsylvania v. Mims 1977, spots where the Supreme Court held that officers may order drivers out of the vehicle for safety reasons, or, at this stage, the officer will state the reason for the stop, or ask questions designed to establish the context. You are not required to answer unrelated investigative questions, but you must provide your driver's license, registration, and proof of insurance, which all states legally mandate. Staying calm is your greatest legal protection because any aggressive, disrespectful, or unpredictable behavior can escalate the encounter and lead to additional charges, such as obstruction, disorderly conduct, or resisting an officer. The goal is not to argue, debate, or prove innocence. Roadside pull. Your goal is to survive the stop safely and legally, knowing that disputes can be challenged later in court. When you pull over correctly, keep your hands visible, avoid sudden movements, and follow instructions calmly. You set the tone for a controlled, safe, and legally secure interaction that protects your rights. Once the officer approaches your window, they will usually begin with basic questions. Do you know why I pulled you over? Or where are you headed? These are investigative queries designed to gather information. But in the United States, you have a constitutional right to remain silent, guaranteed by the Fifth Amendment. However, silence must be used intelligently. In all 50 states, you are legally required to provide 3 things during a traffic stop. 1. Your valid driver's license. 2. Vehicle registration. And 3. Proof of insurance. Failure to provide these can legally escalate the stop, lead to citations, or in some cases arrest. But beyond these documents, you do not have to answer investigative or incriminating questions. If an officer asks, "Have you been drinking?" or "Where are you coming from?" you can politely respond, "Officer, I prefer to remain silent and not answer any questions." This is a legally recognized invocation of your rights under Miranda v. Arizona 1966. Although Miranda warnings are not required during routine traffic stops unless you are in custody, the Supreme Court, in Berkmer v. McCarty 1984, held that traffic stops are temporary detentions, not full custodial arrests, meaning you can be questioned without Miranda warnings. You are still protected by the Fifth Amendment. Sources may attempt to engage you in conversation to assess impairment or nervousness, but you cannot be punished for choosing silence. However, your silence cannot obstruct the officer's lawful instructions. You must comply with orders such as stepping out of the vehicle if instructed, handing over documents, or keeping your hands visible. Silence is not refusal, and the distinction matters legally. Remaining calm and respectful prevents the officer from claiming you were disorderly or resistant. the officer says they suspect criminal activity, your silence becomes even more crucial, because anything you say, however harmless, can be used to build a case. The Supreme Court has repeatedly ruled that your statements during a stop can be used as evidence, even without Miranda warnings, if you were not formally arrested at the time. Silence protects you from self-incrimination and prevents misinterpretation. Always remember, you cannot talk your way out of a ticket or an arrest, but you can easily talk your way into one. Your legal duty is limited to identification and vehicle documents. Beyond that, silence used correctly is one of the strongest legal shields available to you during any police encounter on U.S. roads. 2. One of the most misunderstood aspects of traffic stops is the question of searches. Under the Fourth Amendment, you are fully protected from unreasonable searches and seizures. This means officers cannot simply search your car without a valid legal reason. You have the absolute right to refuse consent politely, but clearly. If an officer asks, "Do you mind if I search your car?" you may respond, "I do not consent to any searches." Officer, this simple statement preserves your Fourth Amendment protections. Refusing consent cannot be used against you, and it does not give them legal grounds to search. However, officers do have certain powers to search without consent under specific circumstances. First, if they have probable cause, meaning they see, smell, or hear something that clearly indicates a crime like drugs in plain sight or the smell of alcohol, they may legally search under the automobile exception, established in Carroll v. United States 1925. Second, a search can occur if you are arrested. If the officer arrests you, they may search areas within your immediate control. A rule refined under Arizona v. Gant, 2009, which limits the scope of vehicle searches after arrest. Officers can conduct a limited protective search, called a frisk, if they reasonably believe you are armed and dangerous. This is restricted to checking areas where weapons could be hidden. Without consent or probable cause, the officer cannot search your trunk or locked containers. Many drivers mistakenly believe refusing consent makes them appear guilty. But legally, it is one of the smartest and safest actions you can take. Even if you believe you have nothing to hide, giving consent eliminates your ability to challenge the search in court. The officer proceeds. Despite your refusal, do not resist physically. Instead, repeat your non-consent verbally and allow the legal system to address the violation later. Courts take Fourth Amendment violations seriously, and evidence found illegally is often suppressed. Always remember, consent removes your legal protections, and once given, it cannot be undone. Protect yourself by remaining calm and firm in your refusal, knowing that the law fully supports your right to decline a search during a traffic stop. During the traffic stop, the officer believes you may be impaired. They may escalate the encounter. Under Pennsylvania v. Mims 1977 and Maryland v. Wilson 1997, police officers can legally order drivers and passengers out of the vehicle for safety reasons. You must comply. Stepping out does not mean you are guilty. It simply means the officer is following procedure. At this point, the officer may conduct field sobriety tests, such as the walk, hand turn, one-leg stand, or horizontal gaze, nystagmus exam. You are generally allowed to refuse these tests because they are not mandatory in most states, but refusal may trigger consequences, depending on the state's implied consent laws. Under implied consent, which exists in all U.S. states, your driver's license is contingent on your agreement to chemical testing breath, blood, or urine if the officer has probable cause to arrest you for DUI. Refusing a chemical test typically results in automatic license suspension and can be used against you in court. However, you cannot be forced to take field sobriety tests. These are subjective and often used to justify arrest. If the officer asks questions like, "How much have you had to drink?" invoking your right to remain silent is crucial. Do not guess, estimate, or volunteer information. If arrested, remain calm. During a DUI investigation, everything you say or do is evaluated. Officers may watch for signs of impairment, such as slurred speech, unsteady movements, or the smell of alcohol. If you are arrested, do not argue or physically resist. Doing so can lead to additional charges. Once in custody, You will be read Miranda rights, and this is the moment to remain completely silent. Ask for an attorney and avoid discussing your case with officers or other detainees. DUI laws are strict and penalties can be severe, but many cases are won or dismissed because the driver exercised their legal rights correctly. During a DUI-related stop, your calm behavior, silence, and lawful cooperation can significantly affect the outcome. Remember, your words and actions determine what happens next. Stay polite, stay quiet, and let your lawyer fight the battle later. The stop concludes. You must understand your legal rights regarding when you are free to leave. If the officer gives you a warning or citation, the stop is typically over. They should return your documents and tell you you're free to go. If they do not explicitly release you, you may politely ask, "Officer, am I free to leave?" This question forces legal clarity. If the officer says yes, leave calmly without sudden acceleration or aggressive driving. If they say no, you are still detained, and any prolonged detention must be supported by reasonable suspicion. Extended stops without justification have been ruled unconstitutional, such as in Rodriguez v. United States 2015, where the Supreme Court held that officers cannot prolong a traffic stop beyond its original purpose without new reasonable suspicion. Once the stop concludes, consider documenting everything that occurred. You are legally allowed to record the encounter so long as you do not interfere with the officer. This right is protected by the First Amendment, upheld in multiple federal court decisions. If you feel mistreated, do not argue roadside. Instead, gather information respectfully, including the officer's name, badge number, and patrol vehicle number. Can request this information legally, but the officer is not required to provide a business card. After the stop, you may file a complaint if necessary, but always do so after the encounter ends. Never threaten an officer with complaints or lawsuits during the stop. Doing so escalates tension and can backfire. Receive a ticket, sign it. Signing a citation is not an admission of guilt, it is simply a promise to appear in court. Refusing to sign may result in arrest in some jurisdictions. If the officer used unlawful force or conducted an illegal search, document everything as soon as possible while your memory is fresh. Courts and review boards rely heavily on details. Traffic stops are among the most common interactions between citizens and police, and knowing how to end them properly ensures your safety and protects your rights. Your calm behavior, legal knowledge, and ability to document the encounter are your strongest safeguards. Remember, the roadside is not the courtroom. Win by staying safe, staying smart, and handling all disputes later through the legal system.